All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Don't forget to close the curtain. Where's the curtain closer? This is a flawless performance.
Good morning. Welcome to another session of oral arguments with the 5th DCA. As our marshal indicated, I'm Judge Brian Lambert. I'm presiding here today on our panel this morning. To my right and to your left is Judge Richard Orfinger, and to my left and your right is our senior judge, Bruce Jacobus. Happy to have him here with us this week. We now have 3 cases on our argument schedule this morning. So just preliminarily, if anybody's here from Salem versus Fidelity Bank of Florida, that case was dismissed yesterday, so if you're here, certainly welcome to watch, but we won't be having any argument. Also, there was a case earlier on our docket, Spence versus Countrywide Home Loans. That case was disposed of earlier. So we now have 3 cases. They are all civil cases. Each side is entitled to 20 minutes. If the appellant would like to reserve rebuttal time, we can reserve 5 minutes or some other amount of time if you would like that. If you do have any electronic devices, cell phones, etc., we ask that you put those in either the off mode or the silent mode so it doesn't disturb anybody. That being said, if we're ready to proceed, first case is 12-4580, Hermilio Rodriguez versus GEICO. 5 minutes?
Please, the court.
5 minutes, fine, counsel?
5 minutes or whatever additional time I have, Your Honor, please.
Okay.
Thank you.
All right, go ahead.
Tom Player with the Nation Law Firm for the appellant, Hermilio Rodriguez. Your Honors, words are important, and they matter. Words like liability, which GEICO omitted from the statutorily required language in its selection rejection form, and words like shall, which the legislature included in the statute to mandate the precise language that an insurer must include in the rejection selection form in order to avail itself of the conclusive, irrebuttable presumption that the insured made an informed, knowing waiver of coverage. The issue in this case is extremely narrow. And the issue is whether or not the insurer should be held to a strict construction standard in looking at the statute and in placing that language in their selection rejection form. The issue is not, as you might surmise from reading the answer brief, whether or not Hermilio Rodriguez is entitled to coverage or whether he gets coverage simply because the form was defective. We don't know that. That's a question for a jury on remand. But because the statute that provides for an irrebuttable presumption of an informed knowing waiver is in derogation of the common law, it must be strictly construed. So what we have...
It's in derogation of the common law. I mean, none of this stuff exists at common law. So how does common law have any effect on any of this when it's entirely statutory?
Well, that's a very good question. Is entirely statutory and is a creature of statutory construction and of contract. And in the answer brief, the appellee made a statement that there is no common law right to coverage, and that's not what we're asserting. What we're asserting is that there's a common law right in contract to assert that you did not make a knowing or informed decision about the contract you were entering into. So in that sense...
What's your authority for that?
Well, that's a good question.
I mean, as I recall, the statutes incorporate the common law of England as they existed in 1776, and I will be the first to admit I didn't go back and look and see what the state of the law was in 1776 on that question, but you essentially say that there was a common law right for a knowing and knowledge, a willing waiver, and so Give me your best shot on what your authority is.
All right, at the time that, it's a very good question. At the time that I briefed this case, I researched that, and again, in preparation for oral argument. I could not find anything directly on point in this regard, but I would submit that part of the reason why I couldn't is that it is essentially just patently obvious black-letter law of contract that there has to be a meeting of the minds, and if there isn't, a party to that contract can claim that they did not agree to the terms of the contract. And so,
How's there a lack of a meeting of minds? Your client specifically says, I reject coverage. That seems to be pretty clear as to what your client intended.
well, and again, that's the very narrow issue that we're here on is not whether or not Mr. Rodriguez made a knowing rejection. It's our position that is a question for the jury on remand. The only question here, and it's extremely narrow, is whether or not,
Not including the word liability in the title of...
whether or not any defect, no matter how small,
That's the only, if the word liability was in the title, then we wouldn't be having, and your client made the rejection that he did.
yes, if that were the
We
case,
wouldn't be having this discussion today.
Your Honor, absolutely. If that were the case, the only way that Mr. Rodriguez would be able to show that he had not made a knowing informed waiver is if he could assert that there was fraud, coercion, something else in the, very extreme circumstances in the signing of that. That's not present here. But the very narrow issue is whether or not GEICO is entitled to that irrebuttable presumption, and whether or not strict compliance with the statute is required as opposed to substantial compliance, which is what GEICO asserts. GEICO's position is it was close enough. Well, how close is close enough?
Counsel, I will be the first to admit that you would think that it wouldn't be that hard for a big insurance company like GEICO to copy out of the statute the words that are there. I mean, don't they have that little creature, I forget what it is, a gecko? I mean, maybe he's the one that prepared the form.
Could be.
But at the same time, the insurance commissioner thought it was okay and approved it. And both of you rely on the case, the QBE insurance case. It seems that, the problem in that case was that the words, it said windstorm instead of hurricane.
Correct.
And the Supreme Court said, basically, good enough.
Yes.
So, articulate for me again, because I was having a hard time in the brief really trying to understand your argument. How do you distinguish QBE where the Supreme Court said that using the word windstorm instead of hurricane was good enough?
Well, in QBE, there's two aspects to that. One, you were talking about a hurricane deductible, which is simply a matter of interpreting the contract and trying to determine what the party's intent was in entering into the contract. And the statutory language that's required in there about the hurricane deductible is different than in this case because it is not taking away a common law right. It is simply a notice provision for the insured.
Again, I'm not at all convinced that there's a common law right, but
I think there's waiver was a common law doctrine. It could be a defense to something.
Yes, Your Honor.
Common law. But I think here, this is all statutory stuff. Coverage is statutory. It didn't exist in common law. And how you reject it is, again, statutory. I don't see
Well, before 1984, when they incorporated this provision where you had to sign a form saying we are waiving our rights to coverage because it's required unless you waive it, then it was simply a matter of contract. And as you pointed out, under contract, you could assert
It was a defense.
waiver was a defense. You could assert that, no, I didn't mean to enter into that contract. It all goes under just those standard principles of law.
But if you look at QBE, as Judge Orfinger pointed out, if you read this waiver that your client signed, it's hard to figure out how you wouldn't know what you were doing.
Well, and again, Your Honor, that is ultimately a question for the jury on remand. And by all means, I think GEICO has a very strong case in the trial court, presenting that to a jury and trying to show that Mr. Rodriguez knew what he was doing. But whether or not he knew what he was doing is not the issue before this court, and it really shouldn't have been the issue before the trial court in the summary judgment hearing. And with all due respect to Judge Egan, he took that question from the jury because he found that Mr. Rodriguez had made a knowing waiver, and I think that was outside the scope of his mandate, his judicial mandate, and particularly in the context of summary judgment, where he should only be looking at the undisputed facts. Now, if I can turn back to QBE for 1 second. Go ahead. In the QBE case, not only was it a different type of language that didn't impact a substantive common law right, or take it away, but the court found that there was no penalty for that. And here, implicit in the language is a penalty. If you do not strictly comply and put this exact language in your form, then you are not entitled to the irrebuttable presumption. And that is the penalty. So I think it falls outside the scope of QBE. So, and that's really the crux of the argument. We are not here saying that HERMILIO Rodriguez is entitled to UM coverage. We're not here saying that whether or not he made a knowing waiver. Those are clearly questions for the trial court on remand. It's a question for a jury to decide. The question here is GEICO held to a standard, or any insurer held to a strict interpretation standard where they have to have the exact language where any defect in it is fatal to their presumption of a knowing waiver. Now, if you start using a substantial compliance standard in this kind of analysis, then it's such a trite term, but you go down a slippery slope. I mean, what is close enough? 1 word? 3 words? What about the font size? 12 point? What if it's 11.9? What if it's 10? I mean, it takes away the certainty of strict construction. And when you take that away and you go to a subjective analysis, it removes all chance of any certainty for insureds or anyone else in knowing that they have that protection if there is a knowing signed waiver. So that's the crux of our argument. And the cases that are relied on by GEICO and the majority of their argument in their answer brief all seems to be directed to the question of, did Mr. Rodriguez make a knowing informed waiver? And that's for the trial court. Any questions? If not, I have 9 minutes left, I believe. I'd like to reserve that because I believe I will have some rebuttal. All right. All right. Thank you, Your Honors. All right, counsel, thank you.
May it please the Court, Angela Flowers on behalf of GEICO General Insurance Company. And
did the GEICO write this form? Apparently the GEICO wasn't very good at just copying the language of the statute. Maybe they should hire, is it Flo from that other insurance company?
Progressive, but I think that if anything, the GEICO fell down perhaps in some supervisory role, but I doubt that he was actually writing that portion of the policy. I actually have a very methodical presentation prepared for the court, but it's clear that you have a very thorough grasp of the issues. So I'll just jump right into...
You shouldn't probably make that presumption, really, I don't know.
That's right. That's a rebuttable presumption. Let me ask you, counsel makes an interesting argument, I think, about in his effort to distinguish QBE, and that is that in QBE there was no irrebuttable presumption. There was no penalty, essentially, is his argument. What's your response to that?
All right, let me discuss why there is no penalty within our UM statute. The Supreme Court was faced with the question of when insurance statutes should be held to strict compliance standards. And we're talking about not statutory interpretation rules, because we're dealing with statutes that are plain and unambiguous. And when you look at these insurance statutes, are you going to impose strict compliance, or will substantial compliance suffice? And the Supreme Court looked at 3 different factors in order to apply an analysis to this question. And the first factor they looked at was whether or not the statute contained a penalty. Now, the Supreme Court gave us examples of the types of statutes that it looked to say, oh, there's a penalty, there's a penalty. Does that match up with what we have in QBE? And the statutes that the Supreme Court pointed to were those which contained words such as void or invalid. And what the Supreme Court was emphasizing there is that we have an overriding statute, which they discussed, 627418, which provides that substantial compliance is sufficient in insurance statutes. So to overcome that statute giving the advantage to substantial compliance, you've got to have an express penalty in the statute. That is, one which says that a policy provision is going to be held invalid, void. It has to say that outright. And we don't have that in 627727. As a matter of fact, we have quite the opposite. What the statutory provision does by saying that if the 3 requirements for obtaining a written objection from the insured are followed, there will be a conclusive presumption that the insured knowingly rejected uninsured motorist coverage. That expresses the statutory intent that, in fact, insurance companies should be relieved of the burden of having to pay for insurance coverage which an insured rejected and never paid for. And this arose out of a trend of case law early back, where insurers were constantly finding themselves in court litigating after an insured had given either an oral rejection or a written rejection, once that was added to the statute, but a written rejection which the insured would come in and argue they had not fully understood. And there was such a degree of litigation over this that the legislator felt that they had to step out and make a statement and put into the statute that they wanted to relieve the insurers of that burden. So it's not a penalty, and the statute in no way says that if one word is missing, that the statutory presumption will not exist. As a matter of fact, the last sentence of the statute says, "this form," and that's in the context of 3 different requirements which the statute has put forth in order to have a valid form. That first requirement is that the form had been approved by the Department of Insurance, and that happened in this case. The Department of Insurance approved this form and authorized GEICO to rely upon it in conducting its business practices. The second requirement under the statute is that the form itself fully explain the UM coverage that the insured is electing to reject. This form fully complies in that regard. The form explains the meaning of UM insurance. There's no question that this fully complied with giving the insured all the information that was necessary in order to make a knowing decision to reject this type of coverage. And then finally, the statute has a third requirement, which is that there be a heading on the form. And the statute sets forth an example of the heading, and that is the crux of the situation here, that heading, when put into GEICO's form, was missing one word in a phrase. It abbreviated, instead of using the phrase bodily injury liability limits, the heading abbreviates the form to bodily injury limits. And the question then becomes, and I think we've already addressed whether or not there's any ambiguity created in the form by that, and there is none. So when the legislature says that this form will entitle the insurer to the conclusive presumption, it's talking about this form as a whole, looking at it in its totality, where it's complied with multiple requirements to get to the point of being entitled to the conclusive presumption. So I just don't find that this case is any different from QBE in terms of making the analysis at the penalty stage. What QBE then goes on to do is look at the issue of substantial compliance. and they weigh what level of substantial compliance exists. In this particular case, I've walked through the 3 requirements of the statute, and we have substantial compliance in every regard, just the missing of one word in only one place in this form. So we have near complete compliance, but admittedly, there's no dispute that the one word is missing in the phrase. It's abbreviated to a shorter phrase in the heading. And then finally, QBE looked to see what impact would result both to the policy and to the insurance industry at large if a penalty was to be imposed and if it was to be found that substantial compliance was not sufficient. And the Supreme Court, in taking the totalities of these factors that they look at, I think that it's clear their intent was to accomplish 2 goals. Number 1, to make sure that there wouldn't be an absurd result, to make sure that there wouldn't be some unreasonable requirement placed upon the insurance company in the way that a statute is interpreted. And then the second goal for the Supreme Court was to emphasize that it's not for courts to impose penalties on insurance carriers. That's for the legislature to do, and the legislature needs to speak clearly when they intend to do that. And a penalty means an express provision that the failure to that substantial compliance in and of itself is not sufficient and results in some type of voiding or invalidating of the policy relationship. So taken as a whole, this case falls squarely within the 4 corners of QBE and what the Supreme Court set forth as the factors that should be considered and how they should be applied. And as I indicated at the start of this, we're talking about a statute which is clear, unambiguous, and on its face expresses the legislature's intent that insurance companies can rely upon written rejection forms that substantially comply with the statute, because that intent's expressly set forth, and the statute does not go on to say that mere substantial compliance results in voiding or invalidating the form. It'd be for those reasons that GEICO would be seeking to have this court affirm the trial court's decision. So if there are no other questions from the court, I believe that I could comment a little further about the absurdity of the result which would occur were the statute to be strictly construed to require complete compliance and not just substantial compliance, especially substantial compliance where there's only one word missing, and the absurdity of the fact that we have no dispute that the Department of Insurance has approved this form, no dispute that Mr. Rodriguez signed this form, no dispute that the form was clear and served the purpose it was intended by the statute, and certainly it would be consistent with the Supreme Court's decision in QBE to uphold this rejection form and to affirm the trial court.
Any questions?
Thank you, ma'am.
Thank you, Your Honors.
The distinction with QBE, as I mentioned earlier, is that it does not deal, as this section of the statute does, with the taking away of a substantive right. As far as a penalty, the fact that this portion of the statute clearly says that an insured is entitled to the conclusive, irrebuttable presumption only if this exact language is in the form, is a penalty. There's no other way to read it. As opposing counsel pointed out, the statute is clear and unambiguous. Now, as far as absurdity of...
Let me ask you this.
Yes, sir.
Suppose there was no statute, the statute didn't exist as to what the form had to say, but that was the form that your client signed, and they moved for a summary judgment on waiver. In other words, that he waived the coverage. All right? They said there's no material fact issue. All right?
Okay.
So the judge looks at this paper that's signed by him that has all this, wouldn't they get a summary judgment on that?
I think if there was no statute saying that there's an irrebuttable presumption,
I mean, there wouldn't be.
and it's just a form that they signed.
In other words, you come in and say, Judge, we're moving for a summary judgment on the issue of waiver, that this is the document that's signed by the plaintiff.
Saying, I waived this coverage.
Waive this, and all the stuff's in there that says, what it is, and I mean, how could he counter that? I mean, how do you counter that?
Well, there could be any numerous ways that he may have, that the plaintiff may have to say that I don't speak English, I don't know what I was signing. I mean,
what one might be.
But whatever they are, it still would be a question of fact.
Not necessarily.
For a jury, and under those circumstances, I'm sure that GEICO would probably win in front of a jury, and they may very well win here in front of a jury. But the issue isn't whether or not he knew. The issue is whether they get that conclusive presumption if they don't strictly comply. Opposing counsel mentioned that the purpose of the statute is that insurers be relieved of the burden of paying under these circumstances if there's no waiver. And we're not here saying that Mr. Rodriguez automatically gets UM coverage. We're not saying they have to pay. All we're saying is they do not get the conclusive presumption. She mentioned the factors that need to be considered in determining whether or not there was a proper knowing rejection, and it's set forth in the case of Orion Insurance versus Cox. It's called the Orion test, and there's 4 factors, and the 4 factors are, first, it has to be approved by the Department of Insurance. This form was. It has to explain what UM coverage is, and the form did, and it has to discuss the applicability of UM limits in the absence of a waiver, and fourth, and most important, it has to have that specific language of waiver in the form, and that's where it fell apart. Now, in the briefs, the appellee has made much of the fact that the form is approved by the Department of Insurance, but that's only one factor, and you have to look at all the factors, and if one of them fails, it's our position that under a strict liability, a strict standard, that they do not get that irrebuttable presumption. That's all we're saying, and that's the threshold issue. Then it goes back to the trial court, and whether or not Mr. Rodriguez knew what he was doing, that's a question for the jury. All of the argument about that, which has been the bulk of their argument, isn't germane to this very narrow issue.
Counsel? Further argument?
No. Thank you, Your Honors.
Okay, thank you.